There are several individual acts of legislation, both recent and historic, which combined together have impacted employment legislation and equality within the workplace. Firstly, and in my opinion most important, is the Equality Act of 2010, which the main purpose is to disperse any discrimination in wider society, but more so in the workplace. The main role of the Act is to combine the Sex Discrimination Act of 1975, which aimed to have equal rights for men and women within the workplace, the Race Relation Act in 1976, which was to prevent discrimination on the grounds of race, and the Disability Discrimination Act of 1995, which was to prevent less favourable treatment of those with disabilities. Incorporated into those three previous acts, the Equality Act also protects against various other protected characteristics, such as religion, age, or sexual orientation, to name a few. The importance of this act is highlighted in the scope of the discrimination that it covers. Whilst the previous acts each targeted separate issues of discrimination, the Equality Act offers a wide range of protection. Whilst there can be no argument that this act of legislation has led to greater equality, the case of Hewage v Grampian Health Board 2012 can emphasise that there must be the balance of probability that discriminative acts have happened, which may be difficult to prove, as this extract of the case explains. In considering a claim for sex or race discrimination in the Employment Tribunal, the statutory burden of proof provisions required careful attention only if there was room for doubt as to the facts necessary to establish discrimination. This case may argue the fairness in the Equality Act, as it can be argued that someone may have indirectly discriminated and may not be purposely discriminating the claimant.